Hey, Brian, thanks for taking out the time today and chatting with us. So as we jump into it, can you tell us a little bit about yourself and what your day job is? And
Yeah,
we'll go from there.
absolutely. Yeah, absolutely. Thanks, Peter, for having me on. It's going to be an important topic and, to get out, of the way here. I'm not anybody's attorney. I'm not your legal guru. So we're just going to be, talking about a lot of generalities. And I'm an asset protection attorney, for investors, high risk, professionals, people who own things that don't want to lose things. And, we're really living in a fascinating time right now. And we're seeing laws and policies that are drastically changed every day, and people being sued that normally wouldn't be getting sued. So protecting your assets and your wealth and your legacy and your real estate investments, whatever it is that you're accumulating is more important now than ever, because if you don't have them, then what's the point of, buying them now? So you got to protect them. You got to lock them down. And so I hope that the concepts that we talk about, help you and your listeners understand this area better. And, do you want me to kind of give a self intro, kind of who I am and what,
Yeah,
okay,
that'd
great.
be cool.
Yeah. And so, like we said in the beginning, I'm an asset protection attorney. It's all that I do. Is exclusively what I do. I was selected to America's Best Attorneys list in 2020, Super Lawyers Rising Star list in 2021 and 2015. Lawyers of Distinction list 3 years in a row. I was nominated to the top 100 high stake real-gators list, top 100 in real estate list. It's a lot of different lists because I'm just very passionate about what I do. And I teach about advanced asset protection at various continuing legal education courses for our lawyers nationally. And so what we do is help protect, like I said, investments in real estate and your wealth with this fancy word called asset protection, which I'll dive into what that even means later. And I got into asset protection from just the litigation and trial side of the law, and just having clients being sued and their lives just turned completely upside down with a false sense of security. And a lot of these clients were coming to me after they were already being sued, and at that point, you're just too far down the rabbit hole. It's like literally saying, well, I'm going to go get car insurance now after I got in a car accident. Well, good luck with that, right?
Yeah.
And so that's where asset protection comes into play before you're being sued. So that's why we're talking about this stuff now. And then there's different layers that we'll break down. And I see what's contributing to this false security comes from a few places. It's, people thinking that they don't need to do anything and just ride lady luck. But, that's not a plan. That's just wishful thinking, like going to Vegas and rolling the dice. Or they think that their insurance will always cover them, which it won't. It's important to have. You need it. You need good insurance. But we're getting more and more clients with claims that are radically in excess of their insurance coverage, especially with big issues with real estate, like mold issues, fire issues, things like that. And so they think that their insurance is always going to be there to cover them, which they're not. Their job is to create wiggle room, take your premiums, collect wiggle room. And then they think that these umbrella policies that they get is just basically a big catch-all. Everything else is going to cover everything else. And it doesn't. It really just provides excess coverage or capital with the same escape clauses that your general insurance is going to have. Or a big one is that they think that their family estate plan, known as a revocable living trust, will protect them, which they can't. They aren't designed to, and they only come into effect when you die to avoid probate, which will break down that when we talk about trust later on. But you need to understand there's lots of different types of trusts. So we need to make sure we're working with the right ones.
100%.
Or the really big misconception that we're also going to spend a lot of time on, as well as these misconceptions of LLCs. A lot of people think that they're a one-stop silver bullet, but they missed the first word, first letter. Limited. They tell you straight up in their name they're limited. And then by being in the legal system, the sad thing is, if you just look around, the legal system's broken. We're literally just a sue happy nirvana now. And so what we do is provide peace of mind for clients and lifestyle preservation. And more importantly, we focus on how collectible you are. And then within our network now, we're protecting collectively over $5 billion worth of real estate assets with over 3,000 clients nationally with that fancy word, asset protection. You want me to break down what some asset what that even is?
Yeah. Like go into the asset protection, then I'm gonna ask some follow-up question because we're gonna go into the meat of it, and I'm pretty interested in some other things. So yeah, that's perfect.
Yeah, and so what asset protection is. It's not traditional estate planning. It's modern estate planning. And what we're doing is placing legal barriers between your assets and your potential creditors before it's needed. Like that's it. It's just a barrier, like a safe for your gold or your guns or other valuables. Anything of value like real estate, you want to put behind the legal barrier and out of your personal name, so it's not easily attached with a lien, or reach with a judgment, just like the rich. And I love the Tony Robbins saying, success leaves clues. The rich don't own things in their personal names. Their businesses and their trusts do. They just get the beneficial use and enjoyment out of them while separating out the liability side of it. And so it really comes into like, okay, what's changed in the world? What's changed in the legal system, right? And so over the last 40 years, a hell of a lot's changed. It's no longer about justice, but really about redistributing your wealth from the haves, which is you, the listeners, the people who have, other assets, to the have-nots, your renters, or other people that you're potentially going to do harm to. Now, for people who grew up with the more old school mindset where lawsuits really were never an issue, back about 40 years ago, you could essentially have everything in your own personal name or in a family trust. That was acceptable then. Lawsuits were prevalent back then.
Yeah.
But over the past 40 years, like things that didn't happen in the past or that weren't even allowed to happen in the past, like contingency fee lawyers or law firm advertising, are just commonplace now. And then this created a cultural shift of now predatory, attorneys and a predatory legal system that, again, is no longer for justice, but just purely profits. Mm-hmm. And so, we now have over 40 million lawsuits that are filed in the US alone. Like 99% of all the lawsuits in the world are filed in the US. Plaintiffs' attorneys are constantly advertising for new targets, which means coming after you, and unfortunately, claims, from your former employees, along with employment law claims, harassment, discrimination, wage and hour claims, they're just skyrocketing. And I actually started out my legal, career in employment law on the plaintiff side. So I'm very familiar with how, egregious that area of law is, especially if you're a business owner. And then, like we're talking about, insurance companies are constantly denying your claims now. They want your premiums, but they don't want to pay you when you really need them for those big coverage lawsuits. And then when you get into the world of the high net worth and affluent families that I work in wealth, this level of protection, you now have to also deal with taking in that macroeconomic, like global look. And the big picture here really is that we have a global financial system that has, structurally really deep-rooted issues, along with, government-backed fiat currencies that are now in question. And this also includes the US dollar. The US dollar is not excluded from this, or exempt from this anymore. And then the monetary policy today is really plain and simple, and we're seeing it right now. Inflate or die. Like, look at the cost of living all of a sudden just skyrocketed, just this last year. And then we get governments looking for deep and accessible pools of financing, meaning your money again, along with financial repression, monetary and economic manipulation. And all this is just adding more and more challenges to protect and preserve your wealth. And so it really begs the question in this like present hyper litigious climate and all this global chaos, just how confident are you that you're not going to get sued? And then how confident are you that if you are sued, that legal system's actually going to treat you fairly? And so asset protection is your modern best bet to level this playing field back now. And then we do this by using all the different tools that we're going to break down, like LLCs, the limited liability companies, LPs, limited partnerships as management companies, and then very strong asset protection trust. And what this does is it makes it very hard for creditors to collect on you. And when your plan is then seen as being effective and impenetrable, this then puts you in a stronger position at the negotiating table.
Okay, so that's a lot. It's a lot of meat in there. So let's go back to, let's say I just got an LLC and I put 3 properties in it. And I think I'm going to be good because I got 3 properties in it. They're rentals. Nobody else. I don't have a partnership with anybody else in it. And then I have an umbrella policy. Am I covered?
It depends, really at the end of the day, because there's a lot that goes into like just saying I have an LLC. So there's a lot of misconceptions with LLCs. And so LLCs, the limited liability company, it's like asset protection level 101. It's the entry level base layer along with insurance. And remember, LLCs are easily pierced. It's called piercing the corporate veil. And so when you're getting LLCs, you need to realize like there's 3 real big concerns that we have with them. They're called They're disregarded entities, which I'll break down. Then charging order chasing, like which state do I even set these things up in?
Yeah.
And this annoying word that people keep falling in love with that have no concept of what it even means, anonymity. And these are the three big misconceptions people have when they think they're setting up these LLCs and they're protected. And then they forget that, again, LLCs are limited. Like, it's very easy to pierce these veils, especially for real estate. So once your veil's pierced, it means you're now personally liable. And so that's why we add more layers to the protection as you grow. But for your analogy, an LLC is better than nothing, so like at least you have something and insurance. Yeah. So you're starting off at the base layer. And so I want to spend a little bit of time breaking down these like three misconceptions of LLCs and these unspoken problems, because it really relates to effectiveness, which is what you're setting all this stuff up for at the end of the day, isn't it? Like, for it to be actually effective and work for you as you grow your assets. And so I want you to think about what we talk about through like effectiveness, cost control, and maintenance, because these are like the big four criteria when we create asset protection plans that we're trying to hit on all four of them. So the first problem generally is that most clients have a single member LLC all in their personal name. And the problem here is that courts have a tendency to disregard single member LLCs. Excuse me. So when your corporate veil is pierced, it's not very effective, obviously.
Yeah.
And CPAs tend to set up LLCs as disregarded entities for tax purposes. That's great for taxes, but it's really bad for lawsuits. What being disregarded means is that the IRS is not taxing your business separate from you. It passes through to you personally. And because of this, they're basically worthless for asset protection and lawsuit issues, because that liability also passes directly through to you and you're being sued. And so, but don't get me wrong, like I still use them, but again, that base layer entry level protection. So if you think about winter and you're dressing in multiple layers, it's the first layer that you put in against your skin, that very thin base layer. That's where the LLC is. So generally you're going to have below like $250,000 net worth, anywhere from like 0 to 3 units.
Okay.
Yeah. So that's where this base layer comes into play. And then what you want to do, is for those single member LLCs that are holding your real estate to eventually, as you grow, be owned not by you, the individual, but by a second layer of protection, which should be a multi-member limited partnership, not another LLC. By doing this, what you're now doing is properly layering your protection. So your mid-layer limited partnership will be owning all of those LLCs. And then all those K1s will simply passively flow directly through to the management company. So it's just one tax filing. Excuse me, let me just take a sip of water here real quick.
Yeah, go.
I'm fighting a little cold right now.
So real quick, just to go back, so you got the LLC, you have the umbrella policy, and then you have another LLC that's the umbrella to that first LLC.
No, so really you would have the LLCs at the bottom structure, and then all those LLCs eventually should flow into and be owned by not an LLC, but a limited partnership.
Okay, so an LLP. Got it.
Yeah, they're either going to be like a family limited partnership or just an LP. Yeah.
Got it.
Then what you're doing is now those disregarded LLCs will flow into that limited partnership, that LP, and now you have just one tax filing, which simplifies your accounting. And then you're adding a second layer of protection. And statutorily, limited partnerships cannot be disregarded entities. So now you're cleaning that up and reinstilling that protection.
Okay, so you got the LLC, you got the umbrella policy, and then is there anything between that? So let's just say you have one LLC, umbrella policy doesn't really, it's added protection, and then you have a living trust. And then do you have everything that I just mentioned in that LLP?
So you wouldn't be having a living trust on that for it would be specifically an asset protection trust. So we'll break that down, what those even are later on. So right now you would just have your LLCs and insurance. And then above that, you would have your limited partnership owning all your LLCs And then the great thing about limited partnerships is they can own a bunch of different other assets. Like you can assign your crypto exchanges into there. You can assign your personal stock accounts into there. You can create a business bank account and savings account in there and start putting cash in there and protecting that. Your passive real estate syndications can all go into that management company. So now you're protecting a lot more of everything that you have by utilizing a limited partnership, which you can't do with an LLC.
Okay. And so the only avenue for the LLP is it helps you with protection, not tax, not shielding you in tax liability.
So all asset protection for it to work is going to be tax neutral. Otherwise, you're going to get into issue with tax avoidance and hindrance.
Yep.
And so everything that you set up from an asset protection standpoint, like LLCs, limited partnerships, and all that, is going to be tax neutral. Okay.
Okay.
And they're all going to generally be disregarded all the way up through to you to then file your taxes, like your income and all of that taxes personally. There are different types of trusts and stuff that you can set up, like charitable trusts. There's different strategies. If you were to say, I don't care so much about the liability of the protection side of it, I care more about tax mitigation strategies. Well, that's a different route that you go. Then there's different types of trusts and different types of scenarios that you would go into. And so that's where the client themselves have to decide, do I care right now about maximizing and getting very strong asset protection from lawsuits because maybe I'm a surgeon with a high liability profession, plus I'm investing in all this real estate with even more, layers of risk now. So their risk profile is now off the chart, and they have millions of dollars worth of assets. So now asset protection is the most important thing for them because God forbid you get sued and they'll lose everything. Okay. So it really just depends on what the client's profile is. If they come in and say, I'm retired, I really have no risk from anything, I just care more or less about tax mitigation strategies, and I'm willing to take the risk of lawsuits from like the negligence of my life or other areas, then you'd go into tax mitigation strategies. And so they're just very different.
Okay. All right.
Yeah. And, like the other, big thing that we need to clear up, with LLCs is just like, we were talking about before, where do you even set all these things up in, right? So you hear a lot of confusion on where to go, and you hear about, Delaware, Wyoming, Texas, Nevada, and all these other, better states, great states. Yeah. It really just comes down to what are you holding and where are you holding it at? And attorneys and CPAs have a really, for some reason, convolute this issue up. And so let's say, for example, it's California real estate that you own, and you're a California resident. And then you set up a Wyoming LLC, and then you go and you hold a key piece of California real estate in it. Or it can be like Tennessee real estate or like, whatever, any other state. And you put this piece of real estate in a Wyoming LLC that's not in Wyoming. What you've done is just convert your Wyoming LLC to a California LLC because you're doing business in the state of California, because you're paying the franchise tax, in there because you're a resident there. So you have to legally register it there as an out-of-state business entity. Yep. It's a California property. So if you get sued and have a liability issue in California, a judge is going to apply what law? California law, not Wyoming law. You can't just go buy another state's more beneficial laws and bring it to that state.
Yeah.
But for some reason, people think that's what you can do. And so this is because a judge in California or any other state doesn't care that your LLC is a Wyoming registered or Delaware registered LLC. What they care is doing business in like the state of California, because it's done this big thing called legally availed itself of the privileges of the laws of that state that you're a resident of. Because that's the state that assets in, that's the state that injury or damage occurred, and it's going to be that state's laws that are going to apply. Like I said, you can't just take Wyoming or Delaware tort and damage laws and personal injury laws with you to another state. It doesn't work that way. So again, it just goes to the lack of effectiveness of picking the wrong state to set your LLC up in. And so though you thought you did yourself a favor by setting up a Wyoming or Delaware LLC, you really didn't. You just, you can't, like I said, purchase another state's laws and bring them with you.
Yeah.
And so for assets that are real estate, my recommendation is just use the state that the real estate is located in, because you're not gaining anything by using another state. You're literally just doubling now your maintenance costs and getting nothing of value. And the other really big misconception when you're picking out LLCs at this foundational level is understanding what this word that's really popular right now is called anonymity. Okay. And the thought, people have is that you can just create, like an anonymous LLC and that you can just disappear and ghost and like poof, ghost a lawsuit. And this is just completely false. But I get this question literally every day. When your LLC is sued, you're going to be legally required to appear and defend it. You also have to have, like if you create a Wyoming or Delaware, like these out-of-state entities, what's called a personal agent of service. Their sole job is to literally say, hey, Peter, congratulations, your LLC just got sued. Now go get an attorney and get your butt into court to defend yourself. So once that lawsuit's filed and you're served, the legal process and discovery process in court begins. Your anonymity doesn't protect you at that point. So what's even worse is that if you want secrecy to even work, also known as lying under oath, that's a one-way ticket to jail. And an example of this is that the creditor suing you have the legal right to demand information about the assets you own, including the cryptocurrencies that you own. And the courts enforce this right very broadly, especially when you're, not living in the South. And so at this point, the only way to keep an asset anonymous or a secret is to lie about them and commit perjury. And that's not good. And so we don't advocate for hiding. We just want to have full disclosure of a proper asset protection plan and just set up, a properly working, trust in the strongest jurisdictions that we can, create for an asset protection trust. And that's really where the magic of asset protection starts to happen, is combining that third layer, that outer shell waterproof layer, the asset protection trust, with the mid layer.
Okay, real quick before we go on to that. So, well, I'm going to ask questions about the asset trust. So when does that come into play? And so if you have an LLC, and then the LLP that's covering that, where does the asset trust come into play?
That's a great question. So the second layer, the limited partnership, comes into play around 500,000 to 700,000 nets. And generally you're going to have about 4 units, maybe investing in a couple different states. So you'll have like an LLC in Tennessee, an LLC in Ohio, and you want to start cleaning this up for tax purposes. Your net worth is a little bit higher. You're starting to accelerate your wealth. You need that management company. You need to start operating more like a business and clean yourself up and make your life a little bit easier. The asset protection trust comes into play about 1 million net, which means you probably have about, depending on what state you're investing in, I would say like anywhere from like 5 to 10 properties. It could be spread out in a couple of different states. Either at this point, you could be a full-time real estate investor or entrepreneur or a doctor, a high-risk profession, something where you're visible and going to get sued, and your net worth is about 1 million or more of unprotected assets. 401ks, we don't include in that because they're RESA exempt protected. So that's when the asset protection trust really come into play.
Real quick, go back to that 401ks and like those retirement accounts, like SEPs and everything else. Those are nothing that you count within the protection.
Correct. So when I'm doing a net worth assessment on someone of what I'm going to protect, if they're like, for example, 401ks are RESA protected, it's exempt. So creditors can't get into your 401k and pierce that while it's growing. They can probably get into it once you're withdrawing it after age, like 65 and a half or something like that. But that's the whole point of creating, 401ks and a RESA protection, is to stash money away for your retirement. So the government excludes that money for what creditors can come and collect on you on. And then same thing like Roths and IRAs. Each state is a little bit different on what they will exempt, but they're really strong exemptions for those. So general rule of thumb, we just don't include those in a net worth analysis because I'm only looking at protecting what's not exempt and what's exposed.
Okay. All right. That's crazy. I didn't know that. Okay. All right. Let's go back to, sorry, I stopped your flow on the asset trust.
Yeah, no problem. So the asset protection trust is that final layer. So you have the first layer, LLCs, base layer. Second layer is the limited partnership, the management company. It's going to be like a merino wool sweater, or a cardigan for you ladies. The third layer is your bad weather outer shell layer. Like you're in Siberia, it's really cold in your middle of winter and you need to stay warm and protected. It's the heart and soul of the system. And trusts have been the longest lasting entities of all entities. And they even go back to like the Roman times for holding assets.
Mm-hmm.
But when done right, they're very, very strong. And they can be sculpted to fit how you need them. And they can morph as you need them without dealing with funding issues that you see with LLCs and other business entities that also then would lead to piercing those veils. Because one of the greatest ways to pierce a veil is, of an LLC, besides like commingling assets, is just bad initial funding.
Yeah.
And so I just love trust. And having a trust at the very top of your planning is just very powerful. And this is where creating an asset protection trust, and more importantly, picking the proper jurisdiction comes into play. And so like Baskin Robbins, like we were talking about in the beginning, trusts come in lots of different flavors and types. And so the standard 101 trust that everybody's familiar with, from the 60s, is the Family Revocable Living Trust.
Yeah.
And so trusts don't die, so when you do and actually funded your trust and transferred, ownership and title into it, you don't have to go, through the courts and probate. And it changed the landscape of estate planning. Then you also have what's called land trusts for real estate, that you hold your land and, connect them to LLCs. But land trusts don't have any protection in and of themselves. They're only as strong as the LLC that you connect them to. And land trusts are just privacy mechanisms. They're not protection mechanisms. Okay.
So
what's that?
So just real quick, since we're on that topic, and I'll let you get some water here, but so if you have, 123 Main Street in a land trust, then above that you have the LLC that's, and that land trust basically is, 123 Main Street as well. So no one's going to know that, Peter McKernan owns that. Is that kind of
correct? It would just be like, it would just be the title of it would be like 123 Main Street Trust or whatever. Okay. And so the issue with the land trust is, let's just say you held the property just in the land trust, okay? And the land trust got sued. Well, there's no protection mechanism in there, so you're still going to be liable to the creditor. That's why you have to connect the land trust to at least an LLC to get the protection through the LLC.
Got it. Okay.
That's why you see them combined together. But just realize it's only as strong protection-wise as the LLC. But then it gives you some protection, not protection, but some privacy because it's a trust. Okay. Mm-hmm. So they're not going to know, like, Peter owns this. They're going to say, well, 123 Main Street owns it.
Okay.
All right. Okay. And then from there, you have higher levels of trust that are called asset protection trust. And this is where I want to spend some time, with this and break down the three types. And then after this, I think like most of you and your listeners are going to know more than 99% of attorneys out there about asset protection trust. And so these really came in about in the early 1980s. And an asset protection trust is what's called a self-settled spendthrift trust. So all self-settled means is that you're creating it for yourself. And so they're for you, by you, as your own beneficiaries. And they have very important spendthrift provisions in them. This lets you protect your assets while you're actually living from creditors and not having to relinquish control of your assets. The difference is they allow you to protect the assets, not, just for your grandkids, but for yourself, which we weren't allowed to do in the past.
Yeah.
And you're somewhat familiar with, another type of self-settled trust that I mentioned called a revocable living trust, right?
Mm-hmm. Yeah.
Many of you have them, like your family members have them, your aunts or uncles or parents have them, grandparents. They're the same in that they're self-settled, meaning created for you, by you. The difference is that with an asset protection version of this trust, it includes these critical provisions called the spendthrift provisions. And what spendthrift provisions are is they are provisions that allow you to protect your assets from creditors. They are the actual teeth behind it. And for those to work, the trust has to not be revocable, but irrevocable. And so it's a very different type of trust, just like chocolate and vanilla are different types of ice cream. They're ice cream, but they're different. And so now this is where the fun really starts to happen with trusts. There's two major schools of thoughts. There's international and domestic. So you can either set them up in the United States or offshore. And there's pros and cons to both. And so I think I'm going to talk about them both and through like a historical context real quick, because it's very important if you're going to understand how, trusts work. And then like the last trust, the hybrid trust works, to understand these base components. And so again, you really have these three options. You can create them domestically in the US, or you can set them offshore in another country like the famous Cook Islands, or you can create a hybrid. Now, for the historical context, the offshore actually came first in 1984 in the Cook Islands, where they created an asset protection trust. And, I like and choose the Cook Islands if and when it's applicable, just because it offers the best home court advantage. It's just the strongest. And why it's the best is because asset protection is what these trusts in the Cook Island statutes were specifically drafted for. And the power of the foreign offshore Cook Islands trust is this fancy word called statutory non-recognition of any other jurisdiction, court orders, or judgments in the world, including the United States. What this means is that if you have a judgment against you in the United States and they take it down to the Cook Islands, your U.S. judgment is just worthless. It literally has no value whatsoever. Statutorily, the Cook Islands are prohibited from recognizing it. If somebody wants to sue your trust in the Cook Islands, they would have to start their case all over from scratch. The person suing you would have to prove their case beyond a reasonable doubt. So the murder standard, the highest legal standard in the world, the 99% sure standard, not the 51% preponderance of the evidence, I'm not sure standard, like sure, let's just give it to them. So 99% sure standard. You can't get a contingency fee attorney to represent you because they're not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States, but that got changed in the 60s. The claim, meaning the lawsuit, is not amendable, meaning that once you file your complaint, that's it. You can't change or amend it after discovery like you can in the United States and then decide to completely sue you and change what you're getting sued for. It's not allowed. The person suing you is going to have to front the entire court costs plus flying a judge from New Zealand. And if you lose, you pay. And so this is one of the single worst things that we don't have in the United States, that the loser doesn't need to pay the legal fees and costs of the winner. So if you get sued by somebody, for a completely bogus reason, I mean, just like a completely frivolous lawsuit, and you spend $200,000 defending yourself in legal fees, and then finally the court throws out that lawsuit, you're still out $200,000. The person that sued you is not going to be getting the bill, because our legal system in the United States, that would discourage lawsuits. And so our legal system is run by trial lawyers who don't want to discourage lawsuits. Not to mention, the statute of limitations is short, and so it's most likely already run because it's only 1 year. Now, if we compare this to those four things I mentioned, remember that four-part test, like effectiveness, cost, control, and compliance? Mm-hmm. I mean, effectiveness, 5 out of 5 stars. Statutory non-recognition, it can't get any better than that. But the drawbacks, all right, control, cost, and maintenance, it all falls short to be purely foreign on that. The cost will be very high. You're generally talking about, $50,000 or more to set this up. And then to be purely foreign, you have a lot of IRS reporting compliance, and disclosures to file every year. You're talking about IRS forms 3520s and 3520As, which are full balance sheet disclosures. And at sometimes the entire trust agreement needs to be filed with the IRS. And those forms aren't cheap for CPAs. They're going to charge you a lot. And most CPA firms don't even want to deal with them anymore because the time that they have to put in to actually do them and complete them isn't worth the time of, the money that they charge you to do them. So a lot of CPA firms are just completely not doing the foreign, documents anymore. So it's going to be hard to find a firm that even want to do those.
Yeah.
Yeah. Then you have FACTA disclosures, which, for all foreign trusts right there for tax compliance. And you got to be out of control. And that's why the trust works so well. Like the foreign trust, you have to be out of control for it to work. And so for many clients, all of those things, it's just not comfortable for them. So while you literally have the most effective trust in the world by far, it's not something you generally are going to be starting out with because of all those other drawbacks. And so then it goes to the next option, the domestic trust, the US-based domestic trust. This came in about 10 years later, started off in Alaska, and now we have about 19 other states that all came into the party, creating some sort of, self-settled spendthrift legislation like Wyoming, Delaware, Nevada. And so the states are jumping on board, seeing that our legal system is now a threat and that things need to get done to protect your assets. And so asset protection in the United States is very valid. And so it's really important to understand that asset protection as a concept, it's important to understand that it is valid. It's just how you do it is where it gets really important. The issue with a purely domestic asset protection trust is one, not all states recognize them. Not all states have them. Like California doesn't have self-settled spendthrift legislation. They don't recognize asset protection trusts. We have a constitution, and in Article 4, Section 1, we have the full faith and credit clause. And this means that every state must grant full faith and credit to the jurisdictional proceedings of every other state. Excuse me. What this means is that, for example, Nevada can pass an asset protection statute, which they did, but it can't ignore a California or Washington or Florida court order. So where the Cook Islands can literally just take that judgment and throw it in the trash, Nevada can't. They actually have to respect it constitutionally and even litigate it. And then courts are ignoring the choice of law clause. The legal landscape is just completely shifting again. And then failure means breach and then asset loss. And this is just completely unacceptable. So I'm not a big fan of anything that's purely domestic, especially at the higher level of risk. And like when you get to higher levels of net worth, that doesn't have a built-in offshore component to it. And that's where the hybrid version comes in. And that's what's called a bridge trust. This is where we start off with like 95% of all of our clients. It's the hybrid. Just think of like a hybrid car. Okay. And what you're doing is just combining the best of both. It's been around for over 28 years. And at the end of the day, it's a fully registered foreign offshore asset protection trust, with all that 40 years worth of statutory non-recognition case law up to the Supreme Court. So it's fully registered offshore from day one with an offshore trustee in standby just in case you need them. But we build a bridge back to the IRS for IRS tax purposes. So the IRS classifies the trust as a domestic U.S. trust by complying with USC section 7701. So it's literally like having two passports. You can have your Swiss passport and your US passport, but as long as you have your US passport, you're going to be considered a US resident. And so because of that bridge, as long as we have our compliance in place and we stay classified domestically, what this means is that the trust is now cheaper to set up and it's going to be more flexible. And then you have none of all those annoying IRS compliance or really no IRS tax filings and disclosures at all, because that foreign trust is now actually classified as a domestic U.S. grantor's trust. But you now have the power of that offshore trust if and when you need it. It's now in your toolbox in your back pocket. And the way we exercise it in that like doomsday duress lawsuit is we break the bridge of IRS compliance by removing you as the trustee during a really big lawsuit. And so the hybrid trust is just extremely effective. You maintain control of your trust right up until the last second where it's not in your best interest to maintain control. The costs are going to be more reasonable. And then with maintenance and compliance, there really is none while it's domesticated. So while you're investing, just think about, the three different layers that you would be, dressing yourself in going out in the cold. Base layer LLC, mid layer, sweater cardigan level limited partnership. Bad weather, we're going out skiing. It's going to be a really bad day today, but we're going to have some fun and protect ourselves. Asset protection trust, and then be as flexible as you can with the bridge trust. And then from there, you're hitting all of those measurements: effective cost control and compliance. And you kind of, have a really strong system with that at that point.
What about, there's a lot. We can talk we can talk for a few hours on this. Let's talk about you or I are going to buy a house, and obviously we don't want to put it in an LLC just because the tax purpose is a little bit tricky. What would you do there? So I'm buying a primary residence.
Yeah.
And doesn't matter what state you're in, to protect yourself there when when you're going to go get sued, or hopefully you don't get sued. But what type of protection?
That's a great question. So hopefully at that point, you're ready for an asset protection trust, some version of an asset protection trust. It would go directly into the asset protection trust. You don't want to put your primary residence into an LLC or some sort of business entity, because then you lose all those tax credits and benefits of home ownership.
Yes.
And that's a lot of money to leave on the table. I think it's like $250,000 tax credit, like in capital gains and all that. So that's a lot of money. Yeah, that's a lot of money to lose. And so the way you protect it and not lose that is you transfer it into the trust directly.
What if you did like could you do, and just because going through your process, can you do a land trust and then do it into the asset protection?
You wouldn't. Your trust is an asset. It is a trust.
Okay.
So,
Okay.
yeah,
Got it.
like that's what we wouldn't even use a land trust in this, and we
Got it.
generally don't use land trust in general ever at
Okay.
all. Yeah.
Got it.
Some people will be concerned about, oh, well, if we're not ready for an asset protection trust and all we are is using, like the bottom two layers, LLCs and limited partnerships, we're afraid of the due on sale clause happening, of transferring it. And I would just say, well, we've never, over like 30 years of doing this and having hundreds of clients in our network that I have to manage, of attorneys and firms throughout the nation, and billions of real estate transfers, we've never seen a note being called due because you transferred out of your name directly into an LLC. The only triggering event that we see that causes that is the bank saying, oh, hey, they transferred title, but they're not paying their mortgage. That's the issue, is you're not paying your mortgage, not the fact that you transferred it from your name to your LLC.
Yeah, I've done that a couple of times. I haven't had any issues. I've had, clients do that. No issues.
No issue. Like the 3 times I think I've ever had to deal with it was the bank just saying, oh, hey, we noticed your client transferred this. What's going on? Like, we're just transferring it for asset protection into an LLC. And literally they say, okay, great. Thanks for letting us know.
Yeah. Like some of the big banks, like, that are out there, they have like a catch-all email that you just email in the information, and then they say, okay, sounds good. So, okay. So you had a lot there. I mean, I wrote a ton of notes down to reiterate, for one, for the show notes, and then 2, just for, putting a little extra on the podcast and the email, or on the website. But so, like, going forward, if you're in a state, because you said some states, right, don't do asset trust, right?
Some states don't recognize them, like basically all the coasts, East Coast, West Coast.
Okay, so I'm in California. So
Yeah.
What do you suggest for me?
Yeah, so California.
Or anybody that's in.
I was from California. I did most of my trial work all in California. So there's this great thing. There's this case, Kilker versus Steelman, 2012, that came out, which was basically put an end to domestic asset protection trust use for California residents. And so it was a California resident who went to Nevada, created a Nevada asset protection trust, put all his money, all his real estate investments in there.
Okay.
It was a pool contractor, I think is what he was. And so this case, they came down and said, well, guess what? You're a California resident. You're not a resident of Nevada. We're not going to recognize that anymore. Plus, we're creating a 10-year look-back period. And because of the nature of your profession, you should have had a reasonable expectation that you were going to get sued. And so they created a whole entire new reasonably foreseeable creditor clause as well for the 10-year look-back period. And that's where that came. So that completely changed the landscape for California residents. And so if you're a California resident, going to Nevada is not going to work to get a Nevada asset protection trust, or doing like a statutory Delaware trust, which is not even an asset protection trust. It's more of a tax mitigation strategy to avoid franchise tax. It's not going to work for you. So what we do for you is use basically this system is we would create the lower levels, LLCs, limited partnerships, and a bridge trust. We would pick Nevada as the state to create your asset protection trust in, but not create a full Nevada domesticated trust. We would just use it as the situs, meaning like the location of the registered trust. And then the trust that we're using is a foreign trust. Okay. So at that point, all we care about is if a doomsday lawsuit does happen, I'm breaking the bridge and moving the assets.
Got it. Okay. All right. Makes sense. And then let's see. So for that, and then can you just talk a little bit more about the Cook Island Trust? Just that's one of the biggest ones, like the best protection, right?
Yeah. What would you like to know about?
Just in the sense of just go back, just to, you don't have to go in depth because you went pretty far in depth, but what are the key indicators there to go there, outside of it being the best one? Just to go over, recap that real quick.
When would I, or just what is the strength of it?
What are the strengths of it?
Yeah, the strengths of it is, the statutory non-recognition, for one, that they don't recognize any other country's court orders or judgments whatsoever. And so that alone, and that's because that's what they do. That's the only industry they have. They don't do, sugarcane. They don't do black pearls. They don't have really tourism. This is the only thing that they do. So they're always on top of their statutes and laws. And again, it's going to be an irrevocable trust. What's another really strong one is, like I said, the you got to prove your case beyond a reasonable doubt. 99% sure rule, versus here in the US, it is a preponderance of the evidence. Maybe 51%. Yeah, I think that's what happened, but that's kind of like what our civil lawsuit, standards are, preponderance of the evidence. So you're using the murder standard for there. The big one, if you lose, you pay, which we don't have here. Massive deterrent for lawsuits. So you got to front. If I'm suing you, Peter, I have to front the entire court cost plus pay to have a judge fly in from New Zealand. I can't take my U.S. attorneys with me there, so I have to find an attorney there, pay them an hourly rate, front the entire cost, prove my case beyond a reasonable doubt, sue you within that 1-year window of opportunity, and then if I lose, I pay. And so, like, the likelihood of winning my case by 99% is
very slim.
It hasn't been done. Even the government, who are the only people that can jump through all these statutory hurdles, still have not won cases down there. And so, like, that's the ultimate deterrent.
Gotcha. Okay. So with all this, what should someone go to first? Like, if they have a LLC set up, so the next, you just call your attorney and just get, the ball rolling? Or
I would say look at it as a sliding scale that we mentioned, and then say, because I look at it holistically. I just don't just look at it as like, what real estate do you have? I look at it as, what are your assets, but what's your day job? Because I need to look at where are all the different avenues of your life that you can get sued from, including the negligence of your life. It's date night. We're going to go have a beer or a glass of wine. Someone jaywalks and you T-bone them with your car. Next thing you know, you're getting sued for, wrongful death. You're going to get cleaned out. Like, just things like that happen. Or I have cases like some clients, there's a California doctor owned a property in New Jersey, rented out to a gang member, didn't know. Fight broke out, guns were pulled, someone got shot and killed. Who's getting sued for negligence and wrongful death? California doctor. Or there's a Louisiana case that came down like 5-6 months ago now, I think it was. Airbnb renter rented it out. People party at Airbnbs all the time. Person got freaking plowed. Ran out the backyard, did a head dive into a shallow pond on the property, broke their neck, became a quadriplegic, sued the guy, got an $11 million judgment out of him. Okay, so like, I would say, look at what you have, how your assets are managed, what your risk is, and then from there, we'll do a risk analysis. You want to do a full risk analysis and asset analysis and see where in that sliding scale do you lie. Are you just at the LLC and insurance level? Are you leveling up to now need the management company? And then from there, this is what we're looking at, is the different levels that you're at, but setting it up to making sure as you progressively grow, the asset protection plan needs to grow with you. Just like most people forget to scale up their insurance as they grow.
Yeah, for sure. 100%. Yeah. Do you have any suggestions on, because I know, before I get you out of here with the last couple of questions, do you have any recommendations on like umbrella policies that it's like not specific companies, but like, some are going to protect you, like maybe some things to look for? Because sometimes someone's like, yeah, I got an umbrella policy, but it didn't even work because it wasn't covered this. Is there some things that you've seen like, hey, maybe you should look at this?
No, I think it's a good to have, to be honest. I would just say what you need to do is understand what the purpose of umbrella policy even is for. It's not it covers everything else type of thing. It just provides more capital, but they're still going to have the same wiggle room, which is through intentional wrongdoings and fraud. But that's not saying you're a bad person and what happened was because you intended it to happen, like me punching you in the face. No, it can be something as simple as saying, there was a piping issue in the property and a pipe burst and caused all these problems. And there was an email that you typed and sent and click send. That email is an intentional act by our legal standards. So a judge will say, well, you wrote this email addressing, like whatever topic. The act of sending that email is an intentional act. Now the insurance defense's way out of saying that is, well, now there's a potential intentional element of this wrongdoing. We don't cover you for intentional acts and wrongdoing, so we're not going to cover you now for that amount. If you think you're wrong, go ahead and sue us. So what you need to understand is just, what's my claim amount? What are the limitations? And from there, just understand umbrella policies are not a catch-all, like cover everything else. It just adds more capital.
Okay, perfect. Okay. Well, dude, That was a lot. And I know you got a lot of knowledge in this space. So for you moving forward, how can people reach out to you and get a hold of you to talk a little bit about this stuff and where they should be at?
Yeah, they can just jump on my website, www.btblegal.com. I have my website set up more as an educational resource with tons of case law and million, not literally a million, but a lot of frequently asked questions section where you can just like go through there. And so, because I want people to be knowledgeable and educated. So when they do talk to lawyers, they actually have some knowledge to ask them questions and vet them. Or you can just email me, Brian, Brian at btblegal.com, and shoot me an email, and I do a free 1-hour consultation. Whether we work together or not, I'd just rather have you have, a good evaluation.
Yeah. And then anything, I'm kind of doing this backwards just because we went through so much, and I want to make sure people, get in contact with you. Is there any book that you recommend, maybe on this stuff that
on this stuff? That's the weird thing. There's not really any good asset protection. No one's really written a book. So I'm like trying to figure out myself, like, how do I go and write a legal horn book on this for lawyers?
I was going to say, dude, that's a huge opportunity for you.
No, I know. It's just, yeah. So the way that we learn about it as lawyers is, we have what's called APC, Asset Protection Council, which I help run, and we're just trying to educate lawyers to actually increase their knowledge beyond the LLC.
Yeah.
So book on asset protection, unfortunately, they don't really exist. Even in the legal world, you're not taught it in law school. You just learn it by, finding someone that does this exclusively and learning as you go. Great book to read though, personal life wise, The Alchemist. I would say you got to personally grow. It's not about just, growing money. You got to, if you're not good between the ears, you're going to get, lose your money.
100%, dude. I love that book. What about any tool or any online resource that you use to help your business be more efficient?
I'm all about systemization. For me, I would say find a CRM that works within your business, and really, I'm not going to give any specific ones. Like I like Salesforce CRMs, but sometimes that can be pretty expensive.
Yeah.
So depending on where you are, in your field, I would say if you don't have a CRM, I would definitely find a way to integrate one in. Like you'll save up a lot of your time on unnecessary stuff that you're doing.
Yeah, for sure. Well, hey, Brian, it's been a pleasure, especially to have you come in and drop as much knowledge as you did, just because there's quite a bit of it, especially in that space. And a lot of the stuff that you did mention, not too many people know about, especially, even the stuff that you talked about, I know about 20% of what you just talked about. So I really appreciate your time today, and I'll make sure that I put everything in the show notes so everybody kind of grasp what you talked about, and then also can get a hold of you too.
I appreciate it. Sorry for the coughing during there.
No, you're good.
Cold.
Yeah, no, you're good. Well, thanks so much, and then we'll talk to you soon.
Yeah, thanks.